It's 2 o'clock, and we want to get started on time. First, I would like to welcome everyone to this forum. And the purpose of the forum really is to give those individuals who work with the Clean Air Act and other environmental issues at the state level an opportunity to talk about their perception of the Act, any problems that there may be, what they think is working well about the Act. And from our perspective as a member, I'm here really to listen because I'm not an expert in the Clean Air Act, even though I was telling Mr. Barack Tom here that I carry one around with me. So that always impresses people when they stop and say, here's the Clean Air Act. But I'm not an expert. These people are, and that's the purpose of the entire forum, is to listen and just have a discussion. We want it to be informal, and that's why we didn't want to have a formal hearing where members were up here and witnesses were down here, and that's why we all wanted to take off our coats and relax. So, and there's not going to be any real order per se, except I am going to introduce everyone that is here, and then we're going to ask each one of those participants to make a statement. And we recently had an event like this with FDA, and some people interrupted the gentleman who was giving, the lady who was giving their comments. And so, you know, if there's something that strikes you right then and you want to ask the participant, presenter about it, feel free to do that. We just don't want everybody talking at once, and that's always a real challenge here in Washington. So that's our objective, that's our goal, and as I said, the only purpose is simply to have an opportunity to listen to people who have the experience. So with that, I'm going to introduce the participants, and I want to, in the beginning, thank the Environmental Council of States for helping us invite different groups here today from different states. We wanted a diverse group of states represented so that we could hear all sides of most of these issues. So, first of all, we have Mr. Thomas Easterly, right there, who's the Commissioner for the Indiana Department of Environmental Management. We have Mr. Tom Barack here, who is the Commissioner of the New Hampshire Department of Environmental Services. We have Teresa Marks, who is the Director of the Arkansas Department of Environmental Quality. We have Mr. Stephen Etcity, who's the Executive Director of the Navajo Nation Environmental Protection Agency. We have Mr. Robert King, who is the Deputy Commissioner for the South Carolina Department of Health and Environmental Control. We have Mr. Brian Accardo, who is with the Florida Department of Environmental Protection. We have Mr. Paul Tate, who's the Executive Director for the Southeast Michigan Council of Governments, and then we have Mr. Brad Pointer. Perez. Tell me what it is. Perez. I'm just going to call him Brad. We have Brad, who's with the Air Pollution Control. He's the Air Pollution Control Officer at the Imperial County Air Pollution Control District in Southern California. So those are our participants, and Mr. Brian Bilbray, who is also from Southern California, just came in. And
excuse me, clarification.
Okay.
I'm from San Diego. Mr. Chairman, we're south of Southern California. In fact, our slogan is better North TJ than South LA. Just to clarify. Thank you.
Well, I want you to know how glad I am you're here.
Yes, I am glad you are.
And then we have Mr. Brett Guthrie, who's from the state of Kentucky. He's also a member of the Energy and Commerce Committee, and so Brett, thank you for coming. So what we're going to do is we're going to start off, if it's okay, Tom, Etcity, we'll start off with you, and you can give your remarks, and then I mean Steve.
Okay.
Steve. Yeah, Steve. We'll start with Steve.
Sure.
So Steve, if you would mind, we'll take about 5 or 6 minutes, and we'd like to hear your statement, and we can go from there. And like I said, if he says something you want to interrupt and ask a question, that's fine. If not, we'll do it when he finishes. See what happens. So, go ahead, Steve.
Well, good
Be sure and turn
afternoon.
your microphone on.
Sure, yeah, I don't think it's on. Good afternoon, Chairman Whitfield and members of the committee, staff, and all the guests in the audience, colleagues from around the country, other states. My name is Stephen Ed City. As I was introduced, I am the Executive Director for the Navajo Nation Environmental Protection Agency. I'm a political appointee, as many of my colleagues around the states are. Leadership, senior leadership over the departments and programs that develop environmental protection programs and regulations to implement the federal environmental statutes and regulations. Also charged with developing the Navajo Nation's own environmental statutes and environmental regulations that comport with the federal regulatory scheme. And it's also a responsibility that we have to work with our neighboring states. The Navajo Nation is in the southwest United States. As I was explaining to Sparks here, it's seated right at the intersection of the 4 states of Colorado, New Mexico, Utah, and Arizona, commonly known as the Four Corners region. The Navajo Nation is one of the Indian reservations that has the largest land base, approximately 27,000 square miles. We often compare ourselves in land base to the state of West Virginia and states at relative size. The cooperation responsibilities in working with the 4 states has grown as our programs have developed capacity and now are assuming delegations and primacy from the federal government through the various environmental statutes, such as the Clean Air Act. We have been developing our programs since 1973, just 3 years after the US EPA was established by President Richard Nixon. But it wasn't until the late 80s that we started to receive significant increases in federal assistance through the grant programs. And then in the mid-90s, my government, the Navajo Nation government, enacted our version of the Environmental Policy Act, but it was primarily to establish the Navajo Nation Environmental Protection Agency as an independent regulatory agency. So since 1995, we've been on this journey, as many states have, to seek delegations of authority, primacy, and the ability to run these programs the way we see fit, that meets our needs, that demonstrates that the Navajo Nation is doing its part in the region, working with the 4 states, working with industry. The Navajo Nation has had a long history of various types of development. I think we're most known for a lot of energy development that has occurred starting in the late 19th century and really taking off in the early part of the 20th century. Primarily fossil fuel-based resources were discovered on our reservation, namely oil and coal. We also have natural gas reserves, and as some of you may know, we are also the area that has a lot of uranium resources in the ground that were used to help the United States develop its nuclear arsenal and to do a lot of things to establish the nuclear energy industry. The charge that we have, looking back on history, is to attempt to clean up some of these actions that were taken and the development that occurred on the nation, and restore our lands. As you all know, many of these things happened before the U.S. developed an EPA or paid a lot of attention to what was happening in the wake of development. And so we're embarked in that, but at the same time, we have to look forward and look at what's coming down the road, such as the regulations that are being enacted today under the Clean Air Act, and what is on the horizon in terms of future regulations. So we are very appreciative for the invite, and we look forward to talking more in depth and detail and answering some of the questions. But that's just a real brief introduction to give everybody here a sense of what the Navajo Nation is doing in terms of developing and implementing now multiple environmental protection programs within our reservation, within our jurisdiction, to protect our resources and our people, and to do our part to keep the Southwest safe and clean and productive.
So Steve, would I be correct if you all submit the equivalent of a state implementation plan?
Yeah, under the Clean Air Act, under the amendments in 1990, there were provisions put in place that authorizes EPA to work with Indian tribes. And when we develop our plans, they're just, we replace state with tribal, so we call them TIPs. Mm-hmm.
All right, well, thank you very much. And this time we'll go to Tom Easterly from Indiana. Tom.
Thank you, Chairman and members of the committee. The Clean Air Act has been remarkably successful. And that's actually why I have my two handouts. This says just for Indiana, but the left-hand bar for each pollutant is the highest level in our state when the Clean Air Act first had us measure things. And the right-hand bar is where we are now, and you can see tremendous reductions for the pollutants that have been in effect for a long time, and smaller but significant reductions for things like PM2.5 that are more recent. And yes, I have a lead problem at a single battery manufacturer, but this is the data. So it's done a great thing. Our air is cleaner. I have chart after chart showing 70, 80, 90% reductions in individual counties. And people have air that's clean to breathe, but in Muncie by the lead place. And this, I think, is what we have to remember. And then that momentum has carried on. The reason I put the back page on is the cross-states air pollution rule, which is currently being stayed by the courts. It was supposed to make all the eastern counties attainment for particulate matter and ozone, and it's not in place yet. We still have the CARE rule that predated it, is still in place, but there are only 2 monitors left for the standards that the CASPER rule was supposed to meet. Now, there is a new ozone standard, and a lot of these East Coast states don't meet that standard, and that's a separate issue that we need to address. But, and these 2 monitors are local sources. The particulate monitor in Pennsylvania is right next to an industrial facility, and it's that facility. It's not a widespread particulate issue. And the one monitor in Maryland is by a road, an ozone monitor, and that I-95 corridor is a tough thing. So we've done tremendous things, but the act is 42 years old, hasn't been amended for 22 years, and it's time to start thinking about issues. And I appreciate that you are thinking about issues. The thing we in Indiana see is if we're, and right now this country is in a little bit of financial trouble, if we're going to grow the economy of our country, we need clear, consistent, and speedy decisions. And that's been our mantra in Indiana for the last 8 years, and they're difficult to get under the Clean Air Act. We are currently, along with the EPA, litigating against people for pollution control decisions made decades ago. Because under new source review, there's no certainty. You get a permit, you rely on the permit, then somebody says, oh, but that permit isn't the one you should have gotten a long, long time ago. So it's very difficult to make business decisions. All the rules that are currently under litigation make it difficult to decide what your ultimate control requirements are going to be. So depending on what you are, you don't go forward. Manufacturing is heavily dependent on energy. Energy costs are a major driver of whether it stays here or not. And energy costs are going to go up with a lot of these rules. Indiana has been pretty vocal about the mercury air toxics rule because for mercury, which is what it's what it said it was about, although the Clean Air Act makes it be about other things. The benefits that EPA has articulated are much below the cost. They're in the millions, the costs are in the billions. You can argue about exactly how much. That doesn't make sense to us. It's going to increase the cost of our electricity. It's going to make us less competitive as a state, and it's going to make the nation less competitive. I worked in industry. The Clean Air Act's done one good thing for me. My entire career, from joining the New York State Department of Environmental Conservation to now, has been driven by these regulations. So you've employed me for 40 some years. I appreciate that, but that probably wasn't the original intent. But in industry, I worked for a company that when some of the air toxics, maximum achievable control technology standards came out, we simply couldn't comply. I mean, we spent boatloads of money and we were just inept, we'll say, but whatever. So we decided not to make that product anymore and to buy it. But once you decide not to make it and you go to buy, the place to buy is not in the United States because there's not a surplus of those difficult to manufacture cleanly items that happen to be metallurgical coke. So we started buying it from China. The coke buyers told me, I never went there, that the coke we were getting was made by digging pits in the ground, filling full of coal, lighting them up, putting dirt back on top in little villages, and the people had really low life expectancies, as you'd expect, because they're basically living in the emissions that we control here. And then when it's done, they had children hand-pick it, and we got an excellent quality product for a really low price. But the total cost to society, I think, was not what we would like in the United States. We would like to have clean production. That is not what happens under the Act right now. It's a fact that we are internationally competitive. What do people want? They want clean air. They want low-cost energy. I mean, people don't like to pay more than they have to, and they actually want American-made products, but they want them at a reasonable price, and they want jobs. And the fact that the Act is essentially prohibited from considering costs and whether it makes sense to spend that amount of money for that benefit, I think is a fundamental challenge that we really need to think, well, Congress has to do it, but the Act's clear that we can't. We need to balance, have some compromise and say, does this make sense? Because our overall quality of life might not continue to go up. I think that we've gotten most of the easy gains. We've been talking about some of the hard gains that different states are getting. We've gotten some pretty expensive hard gains. We're to some really expensive things in some places, and I think we'll hear maybe from Southern California where they are, which I'm glad I'm not there. So we need an act that the rules are clear, that if you meet the standards, and businesses will step up to the plate to meet the standards if they know that then they can do what they need to do. And the other thing that we're very concerned about in Indiana is the time delay in the process. Pre-construction review for major sources takes, if you look at the days in the Act and the days that states take, you have a permit in about 270 days, but then there's another 120 plus days where people can petition to say they don't like the permit and EPA can object. So you would say, well, after 390 days, are you clear? No. In at least Wisconsin, which we just had a meeting in EPA about the other day, and Indiana, years later, the EPA finally acts on the objections because they usually won't act unless somebody litigates that they didn't act on the objection. So we actually have a facility that its permit needs to be renewed, but the objection wasn't quite resolved yet, and the facility's built. That is not good for moving forward as an economy. No, I think I'll stop there. I didn't watch how much time I was taking. Thank you.
No, that's okay. I want to make a couple of comments. You mentioned lawsuits, and maybe Mr. Edsity or any of you can chime in on this, but I have heard a lot of course, in the original Clean Air Act, citizens' right to sue was given because that was a good way to enforce the act, and I think it's been successful. But do you find yourself involved in a lot of lawsuits today, or are you, how many?
Yes, I think Steve Brown said it best. He says most environmental commissioners just expect to be sued routinely. I mean, they're not just all on the Clean Air Act. There was one week when I had 5 litigations come in the week. You know, I'm an engineer. I'm used to just going and doing things, and I was pretty new in the job then, and I just went home and shook my head. Now it's, okay, here's another one. We have lawyers. They will work it out. There usually is a settlement, but it's expensive, and it doesn't give you certainty on what the answer is.
Do you have any idea how much money you spend on lawsuits or defending?
Well, I have down now, but I think I have 16 lawyers, so you know, multiply that out. That's what they're for.
What about you, Mr. President?
Thank you for the question. The Navajo EPA has now seen about 3 legal actions since we were delegated authority in 2005 for the Title V operating permit program. And we've crossed over, as my colleague mentioned. I tell my staff regularly that the citizen supervisions in the federal Clean Air Act and in our version of the Clean Air Act, the Navajo Nation Clean Air Act, are important things to consider. But so much work is done, and what we're finding, where the legal challenges are coming from, is outside of our reservation, from some of the environmental groups. And they're not approaching the nation, the Navajo Nation. They're just filing with the US EPA and then engaging with the companies that are on our reservation, that are our lessees. And that's one of the things that we find to be a trend that we'd like to address early on.
Well, Brad, why don't you give us your statement?
Being from Southern California, like my friend said, he's glad he's not from there, but it is beautiful parts of the year. To premise some of my comments, give you a little bit of background of where we actually are located. We're in the southeast corner of California, just over the hill from Mr. Bilbray there from San Diego, in El Centro, right along the border of Mexicali, Mexico, and it's called the Lower Desert. So we do have some interesting challenges that we face that maybe some of the other states sitting around this table may not, just because of the sheer fact that we're located right next to a sovereign nation, a very urban metro area of Mexicali, Mexico. But to get to some of the questions that were posed to the panel here, I don't think you're going to hear anything different about the Clean Air Act. It's been vital to our nation in moving our air quality to a level that's never been seen before, cleaner than it's ever been in the last 50 years. But there are things that can be improved upon, worked out, revised, that would assist the states, the federal government, and us locals. In California, there's 35 local air districts at a local level that are burdened with having to implement some of the regulations that are passed not only at the federal level, but also at the state level. And for my agency, I have a staff of 19 people, a budget of about 1.8 million, and I'm spending upwards of 500,000 just to get to the question that didn't get to me earlier on litigation. I'm currently in active litigation on 2 different measures with different federal agencies, one being EPA and the other being Department of Interior. So from a local standpoint, that's a big concern for me. I mean, a large portion of my budget is entwined with having to go to court as a last result to try to get some resolution to issues that are facing my area. So that's a big concern for Imperial County. Some of the things that do work in the Clean Air Act is the recognition of some of the impacts from other areas, such as the Clean Air Act 179B, which is a but-for provision that does recognize emissions that come from outside your airbase, and in my case, it comes from sovereign nation Mexico. It is quite burdensome to document how much of that transport does come from a foreign nation. That's a burden that has been placed on us not only in but-for transport, but also in the exceptional events rule.
So how do you do that?
We utilize monitoring networks that are established in Mexicali, Mexico, which are maintained sporadically, to not to quite the level that California requires. We do have to use that to show the transgression and the transport of the pollution that's coming north into the United States and Imperial County.
Who decides where to put the monitoring devices?
It was originally set up with the assistance of Region 9 EPA. So the monitoring system that is there has been there for the last 12 years. There hasn't been any additional monitors set up on the Mexican side of the border. They play a vital role, as you know, in any kind of international issue, and we work closely with them. There are air quality task force associated with the Border 2012 and Border 2020 proposed 2020 program, which we are active. I co-chaired the one in my region. That's where we meet with our colleagues on the other side of the border to discuss our air quality similarities, concerns, and how we can assist each other in trying to improve our local regional area.
Are you all in compliance with the ambient air quality standards?
No, we are not. We're not attainment for PM10, PM2.5, and ozone.
And have you ever been in compliance?
We had a clean data finding for ozone back in 2010, but that was prior to the new standards being implemented, so we again fell out. So we'll be starting our planning efforts soon.
With your type of desert and farming, do you have any hope of it ever being within PM10?
The only hope that we have is the exceptional events rule, because that is where we get the windblown dust coming off the deserts and other areas within Imperial County. That rule is vital to us. A part of the problem with that rule is that EPA has the opportunity to subsidize their own judgments over the state and locals in terms of the data that's collected. That's a problem that we've been trying to address with the assistance, working with EPA through this revised exceptional events guidance that's currently been released for public comment right now. We are serious non-attainment, which requires us to have best available control measures similar to the LA area, South Coast, and some of my colleagues that you'll hear from on Thursday in Arizona. We do regulate to the best available control measures we can agriculture, which is very large in Imperial County, 450,000 acres of agriculture there. So those are two of the areas that we would like to see some revision in the Clean Air Act. Another would be provide a mechanism by which to recognize international emission reduction credits. We did a pilot study about 5 years ago that showed that American companies, not only in Southern California, but specifically in my county, would be willing to enter into a pilot program to fund emission reduction equipment to be placed over in Mexico to reduce emissions if they could realize the credit for it, so they could expand. There's a real problem throughout this country with not enough emission reduction credits. So facilities are really struggling with how can, even if they wanted to expand, they can't because there's no availability for them to get the offsets that are required. EPA doesn't recognize any non-traditional sources of emission reduction credits, like mobile emission reductions. They only recognize stationary source emission reduction credits, which is very problematic for companies to move forward with the permitting to revise and increase their operations, or even new facilities coming into an area.
Has EPA accepted your difficulties of monitoring transport across the border, because you've got Calexico right up against Mexicali, you have two urban areas, so trying to, it's not like, we've got San Ysidro, but at least we have some open area where we can, then our monitors can get it. But with your proximity, it's hard, with Calexico right up on the fence. That's got to be kind of difficult trying to get the EPA to understand that it's not going to be an exact science.
You're absolutely correct, and they do recognize it to a degree. Mentioned earlier that our attainment status, the only monitor that we exceed the PM 2.5 standard is less than a mile from the border, where there is thousands and thousands of vehicles idling on end, day in, day night, 24/7, 365 days a year. So
that's a nice way of saying your number one mobile source is a federal government's operation at port. Would you agree?
I would.
Okay.
And what is the practical impact on Imperial County, or what happens if you're not in compliance? What are the consequences of that?
Well, with anyone, if you're non-compliance, then you're forced to plan to come into compliance or attain the standards. And in our area, what recently has been happening when our PM10 status was we were designated serious non-attainment, we had to devise best available control measures on all sources that contribute, the significant sources that contribute to that non-attainment. That requires you to adopt sometimes very rigorous and stringent regulations on businesses like the agricultural industry.
But you're still in non-compliance.
We're still in non-compliance. However, if we get EPA to concur with our exceptional events documentation, then you can discount those exceeding states because it was due to a natural event that was outside your control.
But you're saying the data collection is a real issue and making the determination of whether or not you'll have the exceptional.
That is a limiting factor, data collection, especially for an agency my size and the budget that I have.
Are you responsible for collecting the data?
That's correct, I am. I'm responsible for putting a package of documentation together to submit to my state oversight agency, the California Air Resources Board, whom concurs and forwards it on to EPA. Now, EPA can look at that data and say, you know, that's nice, but bring me some more. You know, give me some satellite imagery or something else that I just don't have the means to get.
So what do you do at that point?
At that point, which is why I'm actively in litigation right now, is because the EPA did not concur, and I'm forced, the only recourse that I have is to go to court.
Mr. Chairman, I hate to interrupt, but there was an interesting item here. 98, when we were on the committee, we passed a bill called the Border Smog Prevention Act or whatever. And the trouble is, it's probably lapsed. What kind of enforcement is the federal government executing at the border for those who are crossing the border with student cards and work cards? Because right now, correct me if I'm wrong, I've been out of the ARB for a while. If you work in a county and you're a U.S. citizen, non-attainment county, you're required to have your car smogged in that county to reduce the emissions on that. The question is, we had foreign cars coming across the border every day. And basically, the federal government was taking the attitude at the border, that's not our problem, we're not here to involve that. And is there any enforcement at all at requiring those with border crossing cards to register, to smog their cars in the state of employment?
There is some enforcement efforts, and that's done at the state level. And in case of California, the CHP is in charge of doing that. So they have limited dollars, limited resources to actually staff people at all the border crossings.
So what you're telling me is the federal government that's requiring you to do that is today allowing cars to cross the border every day that have not been smogged and brought up to quality, but if it was a U.S. citizen coming in from another county, then the state can enforce it.
I think there's just not enough staffing and enforceability from the standpoint to check all those cars.
So this pending lawsuit that you have, is that over the exceptions rule?
It actually isn't, and I should mention that we've successfully mediated that as of Friday with EPA. But it stemmed from the fact that there was non-concurrence on the exceptional event documentation that we provided to EPA. Without having any kind of mechanism to appeal that or mediate that prior to litigation, it becomes very difficult for a local agency to move forward. The result of a non-concurrence is that if you don't revise your regulations to the level that EPA feels they are not sufficient, you have to revise them to become more stringent and more rigorous. And what's the benefit to that if it's not going to make a difference in cleaning the air quality when we believe we have best available control measures in place?
So your position on that is that there's no way you can improve it any more than what it is?
No, that's not my position. We are always striving to improve our regulations to improve air quality whichever way we can. Now that you take a lot of things into consideration when you're adopting rules and regulations. One, that it's going to make a positive health impact. For one, if you're going to adopt a costly regulation to businesses or industry, it has to have some kind of tangible reduction in air quality to improve the air. So you have to take that into consideration as well as cost effectiveness. You're probably going to hear a lot today that that the cost effectiveness sometimes doesn't come into play when EPA decides on their moving forward with tightening their regulations. Well, that's not always number one. Health impacts is number one for most of us at this table. We want to make sure that the air quality is improved from a health impact standpoint. But the reality is there is cost effectiveness that should be taken into account to make sure that whatever reductions you're getting are cost effective.
And in California's law, state law, that is actually mandated, cost effectiveness be given consideration, so you give priority to the most effective system.
That's correct.
For the record, Mr. Chairman, I want to clarify something. Comment was made that the federal government may not have the ability. I want to make it clear, every vehicle that crosses the border, the license plate is punched into a computer before he comes up to the stand. They know if it is a California registered car or not. And so it is within the existing system of customs. It would be very easy for customs to specifically know if somebody has a foreign registered vehicle and is crossing the border with a work permit, where under the Clean Air Act, they should be driving a U.S. Registered vehicle. So I just want to clarify that is system is in.
And Corey Gardner from Colorado just came in. Corey, thank you for being here. Let's go to Bob King of South Carolina and listen to his comments.
Good afternoon, Chairman and members of the committee. Again, like everyone, I appreciate the opportunity to be here. Is that on? And it's been said before, there has been a lot of progress made with air quality throughout the country. And that has happened with a lot of different types of relationships, both at the federal, state, and local levels, as well as the private community. But having said that, there are still issues out there, and I do want to address some of those that I highlighted that are submitted to you, and I'm going to go through that and highlight that point. The Clean Air Act regulates air quality in a pollutant-by-pollutant manner. A paradigm shift to a comprehensive multi-pollutant air quality management approach is necessary to combine pollution control efforts and maximize resources. And I recognize that would be a change that has to occur within the Clean Air Act, but we do believe that is something that the time has come to really look at that, as well as realignment of some of the dates of when these NACs are passed, so that we can bring these things together, we can look at it one time and bring the best solutions to some of these issues that are out there for the business community and improve the health and the levels that are out there. The absence of a streamlined and clear approach for developing and approving SIPs leaves states spending time on process for the sake of process. Rigidity in SIP deadlines has made it easy for groups to petition EPA and negotiate settlement agreements. There are insufficient provisions for input from states which are responsible for implementation of the National Ambient Air Quality Standards, the NAC, in the development of air quality standards. In many cases, our experience has been with the Clean Air Act that the Clean Air Act does not readily provide states with the ability to adopt local solutions to local problems, a core value of our agency. The Clean Air Act's prescriptive approach limits local, more efficient strategies, and such as in South Carolina, we had in 1997 early action compacts where we had agreements with each and every county in the state except for one, which brought the communities together to help identify ways to reduce levels of pollution. And it was a great tool to really not only to affect the change, but to really educate communities about what was causing the problem. We cannot do that today. That's not allowed, although EPA is looking at something called ozone advance, which is somewhat similar. We struggle with the implementation of EPA rules and guidance. Insufficient or delayed information from EPA's delayed permit issuance in many critical cases. EPA must provide appropriate, timely, and written guidance and responses to questions. Appropriate guidance must be issued with final rules with stakeholder involvement from the initial stages of development. Guidance must be applied consistently between EPA headquarters and the regional offices. The SIP process focuses on the NAC, dealing with one pollutant at a time, mainly in non-attainment areas. SIP requirements are not clearly stated in the Clean Air Act, which means EPA must develop guidance documents that create the requirements. This guidance is often not timely for states to make SIP decisions. EPA then over-relies on guidance documents instead of formal rulemaking. NAC attainment dates and dates for SIP submission are unaligned, and I mentioned that earlier. requiring states to address each individually instead of being able to consolidate efforts. A key federalism issue under the Clean Air Act is that there are regional differences in air quality management needs. And the case in point, in the Southeast, we believe we are not limited. We've gone through a lot of study looking at the Southeast, and trying to address VOCs is not going to solve the problem for us. We have to really address NOx in the Southeast, and that's a problem with the Clean Air Act because it focuses on VOCs. Despite research and evidence presented, EPA has rejected these provisions in 6 that we have submitted. Another concern is the lack of transparency in decision-making and the need to treat states as co-regulators. And I do want to say that I think we kind of have a love-hate relationship with EPA oftentimes, but at the end of the day, the states are the ones that really need to go out and enforce the rules. We are delegated to programs. We do a really excellent job out in the states, and oftentimes I believe that we're not looked at. We're looked at as partners, and at the end of the day, we're co-regulators. We're not just a partner in this effort. So, having said that, those are just kind of highlighting the comments that I submitted to the committee.
Would you mind just elaborating a little bit on, you indicated that you really, in South Carolina, should be focusing on NOx instead of volatile organic compounds. Would you elaborate on that just a little bit?
Yeah, we in the Southeast have a lot of trees, pine trees, and the biogenic emissions, we just have, as a result of that, an abundance of VOCs. And addressing the VOCs in the Southeast the way it's intended in the Clean Air Act doesn't really get to the problem. We really need to focus on NOx. And that's just been, it's been studied. It's been studied by the University of North Carolina, the University of North Carolina. Reports have been generated through that process, and that's just been something that we somewhat unique in the Southeast. And I would submit that all of us regionally have differences, maybe not to that degree.
So what you're saying is that because you've got an ambient VOC natural problem, if you chase VOCs, you may be chasing your tail, where the NOx is a human impact that you can model and trace, and thus be able to quantify success or failure based on your actions, rather than chasing your tail with VOC, which could be there forever, even if you eliminated 100% of the manageable VOC. Is that fair enough to say?
Yeah, I think that's fair.
Okay, well, thank you very much. This time we'll go over to Mr. Paul Taylor. Paul?
Thank you. And thank you for the invite. Appreciate the opportunity to be here. The Southeast Michigan Council of Governments is the lead air quality agency for the Greater Detroit area. We work very closely with our State Department of Environmental Quality, the private sector, as well as our member local governments to get in compliance. The good news is, as has been stated by several, is the Clean Air Act has worked for us. Our air is cleaner. We're in attainment for essentially all the pollutants. So it's working in that sense. Having said that, we've got a few concerns. One is an overall concerns with the standards, and that is that for an older mature urban area like Southeast Michigan, the standards could take you in particularly emission offsets, would take you in a direction that works against revitalizing an older urban area. If you're concentrating development in the built-up area, it could be exacerbating the air quality problems at a time when you're trying to do the kind of redevelopment that we want in our kind of area. Another problem, the continual setting and resetting of air quality standards every 5 years. doesn't give us the time to actually see the results of control measures we've previously put into place to meet the old standards, and we're continually changing or faced with the potential changing. As we stated earlier, the problem of not looking at cost benefit is a serious challenge, both in terms of I think in the ozone standards that were recently pulled, some of the studies showed that the costs exceeded the potential benefits. We've got to get that back into the system in how we figure that. The other part relative to public health, and that's the business we're all in, is there's no bright line analysis of if you reduce to this standard, whatever it may be, that you're going to save X number of lives or reduce how many thousands of cases of asthma. We're doing this in the absence of clear science and clear public health. That is, again, of concern, particularly if there's a requirement to reset the standards every 5 years. Another area is the over-reliance on modeling. Reliance on modeling relative to actual monitoring data. If we, looking at the fine particulates, if we went with the initial modeling, our whole region would have been out of compliance. And when we looked at the data, there was an isolated area in southwest Detroit that was causing the particulate problem. We looked at the wind directions and that data and really found it was one steelmaking facility that was causing the whole region to be out of compliance. Fortunately, EPA allowed us to look at that, but if you had looked at the maximum pollutant permitting data, we'd never be in compliance on that or other pollutants. So looking at the data is absolutely critical. I think that applies not only to how we look at the standards, but the control measures themselves. We did a pilot auto emission tailpipe testing, looking at creating data as cars were coming off the freeway. We did remote sensing of the tailpipe emissions. Vehicle inspection and maintenance in Southeast Michigan as a control measure would not make sense. We've got a newer fleet, obviously, in the Motor City. We've got a newer fleet of cars. A very small percentage of the vehicles were high emitters. That the data should help drive those control measures in the right direction. That's a further problem. The time frames for compliance. We already heard that we've already taken the largest and most cost-effective control measures. We need more time for the future if we do have to ratchet down further relative to new standards. The additional measures will take longer and be more expensive. Another time frame issue is, I think, particularly with what most of the country is seeing this summer, we've got to look at the data, particularly for ozone, over time with the heat and drought conditions that we're all experiencing, or most of us are experiencing. We're in compliance now. We have been monitoring compliance regularly. We're ringing the bell on exceedances, every other day. So we got to be able to look at that in a rational context that will, that it takes into account the kinds of unusual circumstances that we have today. Again, it's worked for us. We're a little concerned. I don't think I have any other than the members of Congress. I don't have any eastern states. We'd like eastern states to look at their control measures before they come back to the Midwest and the West for forcing us to ratchet down further in helping them. I mean, the quick reaction from a number of the states is you can control the transport issue. I mean, I can appreciate the Mexico problem, a little different issue, but we're in compliance, and if it's any of the eastern states as they're trying to get into compliance, I hope they take into account that we've stepped up to the plate, and we don't have to further ratchet down because they can't meet their standards.
And they're still delivering fuel oil to heat your homes rather than using that for gas.
Absolutely. Absolutely. So bottom line, again, I've just highlighted the comments that I made with the questions, but we think a lot of the things that are a challenge under the Act can be handled regulatorily. The requirement to look at the standards every 5 years and a few things like that is a challenge. EPA has found a way to look at data in our case for fine particulates, that it's one particular source. Ozone, again, getting away from the modeling, which would have had us implementing 30 to 40% more ozone sulfur standards. I'm sorry. Oh, no, that ozone. I get my pollutant straight. The modeling itself would have had us making 30 to 40% more stringent control measures than the actual data show. So we've been able to work with EPA on that, but they need to have the discretion to be able to do that.
Do any of the other participants view that as an issue, this modeling versus actual data?
Yes. What model is that? For the new 1 hour SO2 standard, we've done model validation studies at power plants that have monitors around them and don't have sources nearby. And at best, under the best conditions, we think it overpredicts by a factor of 3. And it's actually worse in a complex area like Northwest Indiana where you have low sources and downwash.
But EPA does have flexibility today to deal with that, right?
We've commented on the SO2 standards.
That works the other way too. I mean, California, we had the problem where we were modeling evaporative emissions, and our strategy wasn't getting the bang for the buck, and we found out that we had grossly underestimated evaporative emissions. So that's why you saw California, we've abandoned tailpipe totally. I sort of chuckle every time I hear EPA brag about tailpipe, but the modeling didn't work. I think I hate to say it, maybe there's some of this geeky ego that their modeling somehow is better than reality. But I think we need to bring it back to check reality every once in a while. The greatest model in the world that doesn't reflect reality really needs to be thrown in the can. But there's a lot of egos, I think, wrapped up in these theories. And I think that coming back to touch base, because it can overestimate, and like we had in California with our evaporative emissions, it showed us that a big problem where we actually had to ask Detroit to start re-engineering their vapor recovery system.
Are you finished? Okay. Brian. No,
Oh, okay. Well, I just wanted to comment on that, if I may. I think it's important to recognize that there are applications for modeling that are very valid applications, citing, making certain determinations using modeling. I think where we get into problems is when we start trying to designate an attainment area or a non-attainment area, even though we have monitors that may be there. And I think that's where some of the real issues come about. So there is an application for models. And models are very, very good tools that come a long way. But I think the issue comes about when in the face of some of the real data, the monitors that are out there.
Yeah, if I might just add, our experience has been competing models. Even, again, this goes back to the time frame issue, and where you have several different models, and EPA is not willing to acknowledge a more updated version of a model. And just go round and round with data in terms of modeling. And it does speak to the need to acknowledge real-time data collection and the data in the field. So that's been our experience over the past 4 years.
So you feel like you have a model that may be more.
Well, actually, it's not our model. It's just another version of what's called the CalPUF model. But EPA is not willing to acknowledge that because it hasn't been peer reviewed. Again, that takes time, and I think it just goes back to the time frame issue.
Right.
Yes, good afternoon. Thank you, Chairman Whitfield. And thank you for inviting Florida to participate in this forum. Florida has submitted written responses to the questions provided in advance, and I'm happy to discuss those as you see fit. But in my introductory comments, I'd like to identify 2 key issues for your consideration. The first is Florida appreciates that Congress structured the act to allow states to implement federal air standards through state implementation plans. And Florida knows Florida best, and state implementation plans facilitate the cooperative federalism envisioned by the act. Now, that said, it is important to note that the development or revision of a plan takes time and resources, and this is true at both the federal and the state level. It is a process, and this process is what Congress intended to ensure adequate stakeholder participation. Now, this process fails when lawyers circumvent Congress's intent by settling citizen suits behind closed doors without stakeholder participation. And a recent example of this is the settlement of a suit regarding the regional haze component of Florida's state plan. And I can hold the details, but know that Florida was not informed that a suit had been filed until the settlement agreement was unveiled in the Federal Register. And that settlement gave Florida a mere 4 months to revise a plan that had taken years to create, or else face a federal takeover of our program. Now, Florida should have been a part of these negotiations, but we were not. Instead, those negotiations that directly affected Florida's interests were conducted between Department of Justice and special interest lawyers.
When did that happen?
The settlement was published in the Federal Register on December 2nd, 2011. I couldn't speak intelligently about how long the negotiations have been going on. So the second topic I would like to discuss is national performance expectations for state compliance programs. Florida does not believe that there is a one-size-fits-all approach to ensuring compliance with the requirements of the Act. Congress recognized this by allowing individual states to implement the Act through federally approved plans. And Congress understood each state has its own unique problems requiring unique solutions. Now, EPA has its own method for ensuring compliance. It uses lawyers to pursue high-value enforcement actions. And that method may be effective, but it's not the method preferred by Florida. Florida applies substantial resources toward compliance assistance. We invest in front-end education and not back-end litigation. In Florida, compliance assistance means that we work with facilities to help them understand complex process and requirements. Obviously, if facilities avoid non-compliance, environmental harm is prevented from occurring. And compliance assistance does not have to come at the expense of federal inspection requirements or meaningful enforcement action, and Florida's inspection record and enforcement success demonstrates as much. So to be sure, there are many effective methods to ensure compliance with the standards on the Act. The problem is that EPA's method is the measuring stick by which state programs are judged. And nationwide consistency in implementing process is not the goal of the Act. The results are the goal of the Act. And a nationwide measuring stick inherently conflicts with the flexibility Congress intended to provide us, the states, in implementing the federal programs through state plans. So in sum, Florida would appreciate a little more autonomy and flexibility to direct its compliance program to focus on achieving positive compliance results. And thank you.
So do you have any specific thoughts on how you could have more autonomy?
Sure. Well, at the front end, when our programs are being approved, I think it's realistic to expect that we can set metrics at that point in time. I think we should be measured. But let's figure out what's important in our state. Let the state of Florida set a goal of what the level of compliance should be. Of course, EPA should agree to that. I mean, they're the ones approving our plan, but then measure us against that goal. Don't measure us against someone else's goal.
So in this lawsuit that you're talking about, you all were not aware that they reached a settlement agreement?
I was drinking my coffee and reading the Federal Register, and I became aware.
You had 4 months to wait.
The settlement would have given Florida 4 months to act on a regional haze submittal that we had previously submitted, but the interstate transport rules that we had relied on, that had changed between the time that we submitted the plan in 2010 and the time of the lawsuit. So we would have had 4 months to address those alleged deficiencies. Ultimately, EPA pulled Florida out of that settlement. We did protest, obviously. And where it stands now, and I think that there's a new settlement agreement. Again, I didn't see this one in the Federal Register. They did, but actually industry emailed this to me because they saw it filed with the court document. It will give. It didn't change Florida's responsibilities, but it gives EPA until I believe December to act. And the ironic thing is, had someone asked me last December how much time I needed, I would have said 1 year. Would be in the exact same place, and well, I wouldn't be talking about this right now.
Mr. Chairman, I think the real concern we should have with these stories is that what makes the Clean Air Act different than a lot of environmental regs is, first, it is outcome-based, not process-based. Clean Water Act, if you go to secondary sewage treatment, they don't care what happens. The law basically allows you to pollute. It's, permits, process matters. Here, it's the outcome that is measured and is the standard you set by. Number two, unlike so many other federal programs, the locals are the lead agency in the strategy. The feds aren't supposed to be the lead agency. The people on the ground that have to breathe the air, we're empowered with not only the responsibility, but supposedly the authority to address those issues. Next item and this is where I get worried about when I was hearing things changing since I've been out in '95. I walked out of the game, and that is getting away from the quantifiable standards. God, if you want to talk about it, and these guys will know what I mean, spending years listening to toxicologists argue with statisticians about how many people will die per metric ton. The fact is, it was quantifiable. It's not these abstracts. And I'm seeing that the federal EPA is moving away from those standards that have made the Clean Air Act the most successful environmental strategy in the history of the world. I mean, the air in California, Southern California, and in San Diego, twice as clean as it was 30 years ago with twice as many people. But that was done out of quantifiable steps. You knew exactly what you had to do. Now it seems abstract, and I'm not even going to throw into this issue of the courts and EPA getting into climate change, because I don't know, I want to see how these districts are going to be able to determine that this much CO2 or this much methane will cause this many premature deaths, okay? But that's how the act was designed. But I just worry now that it's sort of going into this vapor kind of gray area that I never thought I'd see the Clean Air Act going into. And I just want to open that up to you guys, is that this seems like it's leaving the foundation of the success of the Clean Air Act and moving into a territory that leaves you guys sort of wondering where's the next step. You don't have that defined. Here's a standard. Stick to the standard. Here's what you need to get to the standard. You can quantify it and actually feel it. Now it's sort of abstract and saying, well, it all depends on your definition of obscene.
Anybody have any comments to Brian's comment?
I think one reaction is I agree fundamentally with you. I don't think the science is always there to make those fine, right-line decisions, particularly in the public health side of things. I mean, as you pointed out, how many metric tons of pollutants equal how many lives lost or saved on the positive side. That science in the public health profession, I don't think, is anywhere near where it needs to be, particularly if we're looking at significant ratcheting down of this and making more stringent the standards. It's not always based on the kind of science we would like.
Well, I saw that when we were when this asthma issue was coming in, remember we were looking at lowering the standards for kids, athletic activity in the afternoon, exposure. And I was very opposed to us just lowering all three divisions down, because I know somebody will look at that study 5 years from now and say, my God, look how much more polluted the air is because they've had this many more instances of stage 1 and stage 2. And instead, we thought, and I was successful at that time, and I don't know what's happened since, was having a child athletic alert, a new standard that was different so that people looking at those numbers, but we actually moved it down, and those were at least sold to us as being medical observations and quantifiable processes that there was a good assumption that there was an increased risk to children exercising, and we did that. But I just worry about a lot of the stuff seems to be talking about moving the goalposts on you guys, and then not wanting to set a goalpost because then they'd have to say, okay, once you reach it.
Well, and that's one of the things in my written comments. There's some really good scientists that will tell you that they don't believe that there's any safe level, probably for particulate matter, ozone, or lead. And so that would mean eventually you're going to get to the standard of 0. And you ask EPA, how do you deal with these non-threshold issues? And they talk about the strength of the relationship in the study. So they know that there's other information showing that it may still be harmful, but that's not as clear. And so the act as it's written is requiring every new administrator that reviews one of those pollutants to keep lowering the standard. Steve Johnson, when he did the ozone standard, wrote a thing with 4 tenets he thought that Congress should consider that gets whether or not there's value in that next step. And for asthma, one of the frustrations for many of us in the air pollution business, certainly Indiana, but I know Virginia says they have the same thing, is as air gets cleaner and cleaner, there's more and more asthma cases. Clearly, clean air, nobody thinks clean air causes asthma, but it's not fixing the problem. So where do we stop? How much do we put of society's resources in that quest?
Yeah, thank you. I'd just like to also add that coming from the perspective of tribal governments where we rely on the federal government for a lot of health care, the system has its faults to begin with in terms of how to best treat all types of illnesses on Indian reservations, including these incidents of respiratory illnesses. And I agree with Representative Bilbray's concept of these moving goalposts. I think it's really a disservice to not only the Navajo Nation, but a lot of other Indian tribes that we're going to have to deal with these more stringent standards without really getting to the root cause of what may be triggering upper respiratory illnesses. Out on the Navajo Nation, our biggest pollutant is PM10, and we have a lot of different reasons or a lot of different sources, one of them being we're rural and we have a lot of unpaved roads. We have drought over the past 30 years. We have high wind days. There are days where visibility gets down to 2 miles, and it's just dust in the air. We still have a lot of substandard housing. So there's questions in my mind that are being generated from me and my staff about how do we get a handle on some questions basic to what's the indoor air quality. We have no public health studies to look at some of these issues that are right in front of us, such as the use of non-optimal home heating units, people burning coal in stoves that are designed just to burn wood, and what that does for health for in infants to the elderly. So I agree wholeheartedly that the challenge of trying to find these relationships between sources and emission standards is a real big challenge. And from the tribal perspective, just like many of the states, we'd like to be able to see our factors reflected in these national standards or regional standards. But right now, one of the things that's working against tribes is low population numbers, and then we have to be put into larger populations, and the outcomes of those factors don't always necessarily reflect what's really happening in the smaller region where the Navajo Nation may be, where our population and our livelihood is sort of subsumed by a larger population. So even when we do get health studies, that's one of the big challenges is our factors don't come through in the end.
Okay, thanks. Tom.
Thank you very much, Mr. Chairman. Good afternoon, everyone, and I really appreciate this opportunity to present New Hampshire's perspective on the Clean Air Act and our experience in working as true partners with EPA in achieving the goals of improved air quality and reduced public health impacts. In New Hampshire, our economy and our quality of life are and always will be inextricably linked to the health of our environment. And there's no question but that clean air is a vital component of that healthy environment. For our state and for our region, failing to have clean air, failing to have a healthy environment will directly and immediately hurt our economy and reduce our quality of life. The good news is that New Hampshire's air quality has certainly improved steadily as a result of our cooperation with EPA, both under the 1977 and 1990 amendments to the Act. We have seen significant and continuing reductions in all the criteria pollutants, and yet there is still much more work to be done. Overall, I think it's fair to say from our perspective that the partnership between EPA and state and local air agencies works reasonably well. We believe that EPA is best positioned to set the national ambient air quality standards and the emission standards for source categories that exist nationally, but we also believe that state and local agencies are best positioned to issue the permits, to monitor air quality, to design those air quality strategies that take into account the local conditions. We've already heard a fair amount of talk about the State Implementation Plan, or SIP process, which I think we all would acknowledge can be unwieldy and lengthy. But what I would suggest is it really is a process that is ripe for business process re-engineering. It's really time for us to take a fresh look at how do we design the system? Are there different ways that this very process-heavy process could be simplified, could be streamlined to the benefit of the regulated community, the environment, and all of us who are daily working in this field? And I think there is some good news here through the Environmental Council of the States, the National Association of Clean Air Administrators, NACA. We have been working very cooperatively with EPA for at least a couple of years now on an effort to try to identify ways to streamline the SIP process. And in fact, Bob King is one of the folks who's been actively involved in that effort. I'm sure Bob could fill you in further on the 13 or so different things that we've been working on so far in that arena. But I think that there are some very, very real and important opportunities here for us to pursue, both possibly through amendments to the Act, but in near term by making changes that we can make within the existing statutory framework. I would respectfully suggest that we not throw the baby out with the bathwater here, that we recognize that the SIPs really are the real teeth of the Clean Air Act. They are the instruments for ensuring a level playing field and fair competition, and that states and sources will live up to their commitments to ensure real, verifiable, and permanent emission reductions that lead to improved air quality and public health. The principles of cooperative federalism that underlie the success of the Clean Air Act are embodied in the SIPs, and it is absolutely imperative that the states and EPA be provided with sufficient funding to implement the SIP system in a timely and efficient manner. And this is one of the very real challenges that I think we all face. We've been given a huge amount of work to do, vitally important work, but unfortunately the resources have not been there to enable us to get the work done the way we all know it should be done. In my own state, for example, our funding reductions that we've taken under Section 103 and 105 of the Act have, over the past number of years, resulted in a reduction of staffing levels from 22 to 16 people available to do not just the same amount of work as before, but actually more work, because EPA, of course, rightly and appropriately is expecting us to undertake additional efforts to meet air quality standards. Another very important challenge that we face in New Hampshire, and I share this advisedly, understanding what I've just heard from my colleague from Michigan, is the fact that our ability to improve and to maintain our air quality is complicated by emissions from upwind, large industrial sources, and major urban areas that are transported, sometimes hundreds of miles, by weather patterns that originate far to the south and west of our state. A 2004 report prepared by our staff concluded, and I quote, "Emissions from large power plants in the Midwest and urban areas to the south of New Hampshire provide the vast majority of the pollution that causes unhealthy air quality, impaired visibility, acidification of lakes and forests, and mercury contamination throughout New Hampshire." And again, we certainly can share with anyone who's interested the back trajectory showing where these plumes are coming from. It's simply the unfortunate reality. So, for example, the entire Northeast has been impaired by both transported and local mercury emission sources for decades, which has resulted in freshwater fish consumption advisories across the region. The development of the Mercury and Air Toxics, or MATS rule, to address mercury emissions from electric generating units has been long overdue, and New Hampshire supports its prompt implementation. I must point out that New Hampshire has a long and proud tradition of reducing mercury emissions within our borders. including requiring the installation of a wet scrubber at our largest coal-fired power plant. As a result, in-state emissions of mercury will have been reduced from 1,100 pounds in 1997 to less than 100 pounds by 2013, or a 90% reduction. We would respectfully submit that if we can do this in New Hampshire, it can be done anywhere and everywhere, and we really do need to level the playing field. And that brings me finally to the Clean Air Act Amendment of 1990's creation of the ozone transport region, which has proven to be an excellent starting point for addressing transport issues within the Northeast corridor. But it does not go far enough in providing that same type of requirement in upwind areas that affect OTR as a downwind area. New science and data gathered over the past 22 years conclusively demonstrate that ozone in New Hampshire is largely due to transported pollution. Our federal laws must be brought into the 21st century by providing additional tools to ensure that sources in upwind states are fully addressed either by states or EPA or both. Thank you, Mr. Chairman.
Thank you. Thank you. Anybody have any comments about?
You got problems, we got Los Angeles.
You know, Tom had mentioned how successful they've been in reducing mercury emissions within New Hampshire. Do any of you have anything you'd like to share with us on these mercury reductions? One comment I would like to make, and you all can tell me if I'm wrong or not, but we had a lot of hearings, for example, on utility MAC. And EPA on the utility MAC made the argument. One thing that they talk about almost all the time, the one thing they were talking about frequently on utility MAC was the real benefit would be from the reduction of mercury emissions. And yet, from their own analysis, they showed that the benefit from mercury emissions was almost negligible, and that the real benefit came from reduction of particulate matter. And so we heard so much about mercury, but my impression is that there's not a lot of benefit from mercury reduction under utility MAC. But would you all have any comments on that at all, or?
Yes, but they're unpopular. So we've looked at mercury in fish in Indiana for the past 30 years.
Yeah.
And we know that Indiana has reduced its mercury emissions that we can figure out by about 50% over that time. And there's been absolutely no change. The fish now have the same amount of mercury in them they did before. Now, the good news is the average fish is less than half of the level that EPA finds as bad. So it's good. But we still have some high mercury fishes. And I think it's a worldwide issue. And also remember, mercury is an element. So it's in the earth. Oh, I still know what. And I'm not sure that, it's back to modeling. We have this simple concept that if we stop this identifiable source, the mercury in the fish is going to suddenly get better, and we haven't seen it. And I know that it's Minnesota's published their report, and they show minor changes. They show it's going down for a while, and starting around 2005, it went back up, but they are not major changes. So something isn't working. Because if you reduced your emissions by 50%, you ought to see some change. And you should see, your fish should be really great, 90%.
Anyone else have any comment on mercury?
Is there any data about, one of the concerns I had, Mr. Chairman, when we were going through that, is trying to clean up our act out west, and this issue of pushing industries over into China, and China cranking up their operations, and all the ones, and gifting us with high altitude mercury coming over and dropping it off, God forbid, in the Imperial Valley. I know it was increasing our mercury exposure just because we didn't look at the fact that there was a global generation issue.
Worldwide, it's going up because those countries, they're trying to grow their economy to have what we have, and you can't blame them for that. So they're burning more coal. Same with India, right? They're trying to increase their standard of living.
Well, I think the chairman will remember when we were talking about the concrete production issue. That was very real. You shut it down in California, and that's one thing. But when you shut it down in the Midwest, and all at once everybody starts buying it from China, China comes up with the production, and they're not using clean technology to run those torches.
You know, a number of people have mentioned the SIPs, and Tom specifically talked about the SIPs being the cornerstone of enforcing the Clean Air Act. And you had mentioned that maybe there are some changes in the process. Would you elaborate on that, Tom?
Sure, I'd be happy to talk a little bit about these things. And again, I think Bob King may want to jump in further, and I know Teresa Marks has also got a lot of interest in these issues as well. But certainly from our perspective, one of the things that we probably need to be thinking about is whether the timeline for the NAAQS review makes sense in light of the experience that we've had over the past 20 plus years in working this process. Is there a way to rethink that timeline, figure out what the optimal timeline is in order to get both better development and more coordinated development of the SIP plans? So, for example, one of the things we've been working on with EPA is to try to find a way at the same time that a standard comes out to have the guidance document or even the implementation rule come out at the same time, so that we, the states, are not in a position where we're given a standard we need to meet, but no guidance, no direction on how we're really supposed to get there, and very short timelines within which to make SIP submittals that would show how we're going to get there. And only at the very last minute, sometimes unfortunately even after we've passed our deadlines for submitting our SIP plans, do we get the guidance documents from EPA in terms of how they think we might be able to get there. So that's one thing that we think could be done. Bob's already mentioned this thought of possibly better coordination of SIPs for multi-pollutants rather than looking at things on a pollutant by pollutant basis. Again, to take advantage of some of the common components of SIPs, such as what we call the infrastructure SIPs, which are really the backbone of how we go about getting the work done. I think, also really need to look at this issue of adequate funding to the states and EPA to allow us to get the job done. Right now, the unfortunate reality is EPA does not have the funding and the staffing to be able to participate in a timely and meaningful way with us, the states, as we are developing our plans and drafting our rules for how we might comply with these NAAQS. And if we could have their involvement and true participation in that process earlier, to know what they would in fact find agreeable and acceptable, we think it would help the process very much as well. So those are just a few thoughts that we have. I think it's fair to say that the states have really only just begun the process of evaluating and looking at and trying to learn where do we think there are further opportunities to streamline this, to make it work better for everybody. But that's certainly something that I know the Environmental Council of the states is going to take a look at over the next 5 to 6 months or so, and see what we can come up with for some additional ideas. But there may well be other much better ideas than the ones that I and others have already talked about today.
If I might add just a point on the NAAQS when they come out, it's not just about putting a plan together. We're sitting there with a permit in front of us with this new standard, and it's critical that we understand what is required and the guidance documents and all of that. So while we're sitting there trying to make decisions on new permitted facilities, we're struggling with this new NAAQS without the guidance in front of us. And I understand it's a resource issue many times, but the fact of the matter is these companies they're ready to go. They're looking for a permit process that has clarity and some understanding of what the endpoint is, and we can't give them without that upfront information.
Are you talking about operating permits?
Yeah, yeah.
I got a question for you. You know, a lot of us have worked, stationary sources have been nailed down, they're a sitting target, always a low-lying fruit. The mobile sources has always been the tough one. I mean, it's moving and getting out there. One of the things, and I apologize to the chairman, that I just realized after 10 years on the air board, and 6 years on the air resources board, totally overlooking except for one instance. And when you were talking about the dirt roads, I was thinking, don't gravel your roads with serpentine. We had all the Sierra Nevada with serpentine on there, and all at once it's asbestos. And you can imagine trying to tell all these counties they have to start digging up their roads. But outside of that, the serpentine issue with gravel roads, the whole time I was there, I never heard any of us talk about coming down on the public sector for our inappropriate traffic management and the way we handle that, and the whole issue of indirect source being caused by inappropriate traffic management. I mean, I guess there's 2 studies I keep bringing up where they're talking about 4-way stops, stop sign being 5 times more polluting, that roundabouts are, I think, 22% more efficient than traffic lights, which really astonished me. But all the time I was there, we were looking at the private sector and saying, our job is to get the private sector to clean up their act. But I don't remember any of us coming up before a county and saying, you are closing this road, but you're not going to mitigate for the increased congestion caused by doing this. Or you get credits for putting in this and reducing, I know there's been talk about giving credits for reduced congestion to projects and stuff like that. But how many of us are going back and actually looking at the government agencies that we're coming out of and saying, physician, heal thyself, what are we doing in government to help the consumer not pollute? Then don't give me this, oh, we're worried about safety. That was the argument for not going to fuel-efficient cars, because it wouldn't be safe if the cars were small, right? But let me just raise that issue. Is that a section that anybody is even looking at, or is this sort of sacrosanct where we can't get into it, short of telling the federal government they got to get those cars through the border faster so they don't idle so long?
Yes, could I respond? Thank you. Yeah, in our case in Imperial County, one of the largest contributors to our fugitive deaths problem is unpaved roads. We are a rural agricultural area. And we were required by EPA, since it is a significant source, to identify who's in charge of that, which in this case is our county public works public commissioner. So we had to adopt a rule specific to them on how they would mitigate X number of roads over a 50 ADT threshold. So we do look at our, other public offices and other agencies outside just the private industry in our case.
And what sanctions were you able to use to get them to?
Sanctions is a scary word for us. Well,
incentives.
It comes back to the funding. We're a small agency. The Public Works is a very small agency. There's only so much of their funds they can contribute towards maintaining unpaved, not highly traveled roads. Most of their funds have to go into maintain the paved roads that they have to maintain. What we've done is, whenever there's a possibility for the local air district to contribute to, say, a mitigation measure like a water truck, for instance, in our area, that's the most common, most cost-effective mitigation measure to utilize. So we, our agency, we fund projects or entities that can come up with a mitigation measure to help reduce those. And so for the Public Works example, I'm in the process of buying them another water truck. But then you give them a water truck, they have to have an employee to drive that water truck.
And water, you got the diesel emissions and
diesel emissions, and then water still costs money. So there's other challenges that those agencies face as well.
I just tell you, the whole time I was mayor, I was putting up stop signs, and nobody ever said, you realize that's 5 times more polluting than not having. No one ever raised the issue. Of course, you got everybody screaming at you because they want a stop sign on every corner. But no one ever stands up and talks about that there is an impact of making people stop and start again, especially when you've got things like yield signs and amber light, there's alternatives, but nobody ever brings that up. And the cumulative impact, let's face it, local sources, it's the cumulative impact that we're really getting hit with.
Yeah, in our case, we have the blessing and the curse of being the Metropolitan Planning Organization for Transportation Planning, as well as the lead air quality agency. We're doing some of the things across the board, like lower vapor pressure fuels in the summer, though that has been very successful. But the transportation control measures, traffic signal timing, roundabouts, which are relatively new to Michigan, but they're much more, they're growing like like mushrooms across the region for just that reason that you described. We're doing a lot to reduce VMTs in the region, to the extent that we can, it's got to be done holistically, as you're correctly pointing out. The other thing that has benefited us from an air quality standpoint that I'd be glad to share with the rest of the country is a lousy economy. VMT are down, a fair amount. The good news is it's both are coming
This
back.
town's the worst culprit too. I mean, no right turn on red.
Oh, that's, yeah.
I guess that's DC and Tijuana are the only two cities I remember that.
Yeah. But we've got to look at the transportation operations side of it, and couldn't agree with you more.
I was just going to add, in addition to the examples that Paul has cited here, our state Department of Transportation has been bringing open road tolling to our major highways in the state where we have toll booths, so that even beyond just the easy pass approach where you slow down to 25 miles an hour or so to go through the toll booth. Now there are gantries over the highways, the major highways going through the state, and you don't even have to slow down. If you have your transponder in the car, it's going to pick up your signal. You're going to get charged a toll, and you're continuing to fly right through at 65 miles an hour. And we believe we're already starting to see real air quality benefits in various parts of the state as a consequence of just that kind of open road tolling. So it definitely helps.
So Brian knew more than you thought.
What?
So you knew more than you thought.
There's more guilt, Mr. Chairman, more guilt. I just think that maybe the air districts ought to be requiring cities to think twice and give them cover so they can look at the crowd and say, I'd love to give you a stop sign, but those SOBs at the air district won't let me do it.
Well, thank you very much, Mr. Chairman, and I really also appreciate the opportunity to be here today and to talk openly about these issues and certainly hear ideas from my cohorts in other states on how they're handling some of these problems. I don't want to reiterate a lot that has been said or repeat a lot. I know it's getting close to the end of the day, but let me just say that I agree certainly with everyone that the Clean Air Act has resulted in huge improvements in air quality throughout the nation. And I agree that there needs to be a set of standards that are protective of human health and the environment. Everyone in the nation, every citizen deserves to be able to breathe clean air. And so there should be those minimum standards. And EPA is probably the best regulatory agency at this point to set those standards, and they should be set at the federal level. Certainly they have access to the science and the resources that states individually don't have to set those air quality standards. So that works in the Clean Air Act. The technology issues work most of the time. I think the Clean Air Act looks at recent technology and they're able to provide a lot of assistance to states in permitting regarding the technology to be used. Unfortunately, I think the states do get preempted some in the actual implementation of the air quality standards. And I think part of that has to do with the fact that EPA sends out implementation guidance that they think is one size fits all, that should fit every state, without taking into consideration some of the local conditions that are in those states. And where the rubber really meets the road is in the permitting process. And if you have guidance documents that EPA is using to either approve or deny the permits that you've written or disapprove the permits you've written, then that's really become a rule. It's not guidance. And I think that the states do need more leverage in being able to institute their own guidance and using their own local circumstances to issue permits. When we're talking about SIPs, I have three main areas of concern probably, and they're all related to the SIP process. The SIP process, of course, is necessary. Every state should be able to make their plans on how they're going to bring any counties they have back into attainment, how they're going to implement the air quality standards. Certainly those SIPs are necessary. But unfortunately, in today's world, with the backlog of SIPs at EPA's level and the fact that these ambient air quality standards are reviewed every 5 years, it becomes, as we say in the South, a constant do loop. We're always doing SIPs, and about the time we get the SIP done, it'll go to EPA for approval. Well, that could take years at times. and before you know it, we're reevaluating that ambient air quality standard. So there's a problem with the process. And as Tom said, that's what really, I think, needs to be evaluated more than anything else, is we need to look at the process, the SIP approval process, and how we go about submitting those SIPs, how often we have to submit those SIPs, how many instances we have to submit those SIPs. I agree that we need to be looking at a multi-pollutant process. Their industry, one of the biggest frustrations I've heard them express, which I believe they have a legitimate concern about, is the layering of these different air quality standards on one another, and how they're going to institute the right technology and the right controls to make sure they meet all of those air quality standards. And when they get to that point where they think they've got that, then there might be a standard that's changed. Something's challenged in the courts, or something happens where that standard's going to be changed, so they're having to start from scratch and relook at everything they thought they had worked out, which can be extremely costly. And it also can be damaging to the environment because you don't get those controls put on as quickly as you would. So it's very important, I think, for that SIP process to be sped up, to be looked at for more efficiency, and to make them more effective, because at this point, they're certainly not as effective as they should be. The other issue, of course, that I have concerns about which relates to the SIP process, is the reconsideration of the National Ambient Air Quality Standards every 5 years. Again, as I said, we get into a do loop where we can't get through the actual SIP process or the review of our permits, actually incorporating the new standards until the next standard is in review. So it's constant. Industry has a very difficult time keeping up with those standards. So I think it's time that we look at extending that timeline out. I think 10 years might not be unheard of, 8 to 10 years anyway, to look at reevaluating those standards. In our world, I think it's become just evident that these standards are going to be challenged. There are going to be court cases brought. There are going to be technology issues that have to be worked through. I think EPA would admit themselves that some of these standards, when they came out, they were not, when they were submitted, the actual implications of putting them into practice were not considered probably as thoroughly as they should have been. And with a 10-year process, I think we could have much more, the rules could be much better thought out, the implications of the rules could be thought out, they could be well planned, and we could look at the actual state of the technology better, or EPA would have a chance to do that too. There could be more comments made at the beginning of these rules. Perhaps some of these issues, rather than being resolved by litigation, could be resolved by making changes to the rules during the draft process. So I would definitely be in favor of reevaluating the timeframes on the National Ambient Air Quality Standards.
Does anybody have any comments on what Teresa said there about the ambient air quality standard review?
Did anybody see any way, where's the disaster here? After all these years of working with the 5 and having to fall over ourselves and basically redo stuff, it just seems logical at this stage to go to the 10. Of course, I'm sure there will be people who will attack anybody who proposes it and say we don't care about public health, but from the operational point of view, it seems logical.
10-year makes sense, and I would add to that I'll come back.
Okay.
Can I just pick up on this? I would agree with Teresa that it is appropriate to reevaluate what this time frame is. 5 years clearly is not working for us. I would suggest that what we may want to do is find a process that would allow us to really evaluate why it is that 5 years isn't working. What are the different things that are delaying us? What could we be doing in the SIP development process and approval process that could help us deal with some of the challenges that the 5-year timeline is causing for us, before we define exactly how many years we actually think this is going to be. Is it 7 years? Is it 8? Maybe it is 10 years. But certainly we need to look at all the pieces together here. And I I would respectfully suggest that just arbitrarily jumping to some other time frame is probably not the way we're going to build consensus around a different time frame. We need a process that's going to really engage everybody in figuring out, okay, how do we get a lot of the waste out of this system, a lot of, frankly, the litigation out of this system by redesigning it, meeting everybody's needs, and getting to a time frame that allows us to accomplish that.
You're being appropriately a diplomat on this. I think that we do have historically a constitutional line that 10 years has been used for population, for a census, for our redistricting. We shake it up there. I know you'd like to have, sure those, it's probably easier to sell it and get the legislation passed if we show why there won't be a major damage or major problem stretching it out for 10 years. A lot of times the best way to do that, though, is to in your legislation, bring it back for review after so much time to see if there was a problem with this signal, then legislatively it's ready to be corrected. But I understand your way of how you get everybody to agree with it.
Teresa.
Well, I was just going to say, another reason I think that stretching this out could be helpful is that it will give us more time to determine whether or not the actions we've actually taken pursuant to our SIP process is making a difference. Right now, it's hard to evaluate that in 5 years. But in a 10-year period of time, if you're doing what you need to do, you'll know it. If you're not, you'll know that too.
So how significant is this backlog of SIPs that you referred to?
I think we have 5 or 6 waiting at Region 6 now. We in Arkansas, and
Now, is this on the ambient air quality standard?
some of them are on the standards. We have our regional haze SIP is the only one that they've actually looked at lately. Some of our program SIPs. The regional haze SIP was partially approved and partially disapproved, and by the time and they disapproved the modeling aspects of it that they had approved. We had done pursuant to Sincera, which is an organization that's well respected. We thought everything was going to go fine, and they were disapproved on some issues that we felt went beyond regional haze. They really went more towards other toxic issues besides regional haze. So we considered strongly appealing it. We talked with our industry, we had stakeholder meetings and decided that we would not do that. Some of the controls were going to be placed on anyway. But the problem with that is there's a FIP in place. So we have been delayed, and now we're going to be delayed longer working with our industry to come up with this news on regional haze. There's a federal implementation plan that if we're not done by 2014, then we're going to be FIP, as they say. The federal implementation plan will come into play. And that really, I think, is unfair to the states in that regard. We're trying to work, we're trying to get our SIP put in place. We're working as hard as we can to do that. We have no control over how long it will take EPA to review those and either approve or disapprove. But when you have a FIP out there, you don't get yours done in time, then you're stuck.
Well, there was some discussion, I think some of you alluded to this, that they were going to change the ambient air quality standards like 2 years early. There was some discussion about that. So that would have made it even worse.
At least for ozone, they didn't do that, although they thought they were going to. But so if you look at the standards over time, it's usually more than 10 years between the times they actually effectively change. Because, as they said, they come out with something, litigation for a number of years, then finally everybody settles down and does the standard. So if this ozone standard that went in effect in 2008 is actually changed next year, it will be the first time that they've done, I believe, two significant standards changes in 5 years. And part of the SIP problem that frustrates me is you cannot force EPA to make a decision in a timely manner in any effective way. In theory, you can litigate to make them make a decision, but you can't get there. And that's why I think it would help us if Congress would put some teeth in that under some conditions, and then you'd have to set out what they are, including that you meet the standard and other things. The EPA has to, the answer is yes if they don't act within a certain period of time.
Got to resolve the uncertainty. That continuing issue.
There's been a lot of discussion today of reference to litigation, and obviously litigation is a significant issue. I'm assuming there's not any easy way to deal with that. But do any of you have any thoughts on litigation at all?
Kill all the lawyers seems to not be popular.
So why, if we put them all end to end, it wouldn't be a bad thing?
Well, let me just say, interject here from, again, the tribal government perspective is all premised on this different relationship between the federal government and tribal governments, especially the tribes that have treaties and other agreements with the federal government. As far as the litigation issue is concerned, one of the ways we see positive change would be for EPA as part of the entire federal system and the role that the federal government has in terms of these treaties and other agreements as a trustee. One of the things we'd like to propose is somehow we get better support coming from Congress to make sure that EPA is open and more transparent as a trustee, especially if some of our trust assets are going to be at risk by some of this litigation. From the Navajo Nation's perspective, coal is a trust asset, and it's the foundation of our economy. And it was something that we were provided with in coordination with the federal government over 50 years ago, and now we have attacks from people who are anti-coal. They don't even come to the nation to discuss their issues. They just file lawsuits, and then the EPA goes into this process where we're excluded, and they're doing their job under the statute, but they're falling short in terms of their responsibility to engage the nation as its trustee.
Interior Department isn't required to.
The Interior doesn't really have a role. If an external group is going to file a suit that involves, say, a lessee like the Navajo Generating Station or the Four Corners Power Plant.
Huh.
Some of the states we have had discussions about this and are concerned. We don't want to be involved in all of the litigation that goes on. If there's enforcement litigation, things like that, we don't care. We don't want to be involved unless it's something personally that our state needs to look at. But when you're looking at the settlement of large cases that are going to have an impact on your state resources, then we do feel like we need to have some type of input into that. Now, right now, legally, we figured out about the only way we can do that is to try to intervene as a party. We would, and I know that under the Clean Air Act, many of these lawsuits are sent out for public notice, but we would like to be able to be included on the front end. And EPA has spoken with us about that. We've talked with them about that briefly, and they're supposed to be providing us with a list of the current litigation that they have going on that may affect the states. We're hoping that we're going to be able to work out some type of arrangement with them where we will be consulted or we will have access to some of the information when we do have cases where the state's resources will be affected.
Mr. Chairman, if I may, as a recovering attorney myself, the reality is that all parties involved in the clean air realm have at times relied upon litigation to try to achieve the goals that they're trying to achieve, including, candidly, the states themselves. I suspect there's probably very few states around this table that have not either currently or at some time in the recent past been involved in one or more pieces of litigation at the national level or maybe at the regional level in order to ensure that our interests are being considered. Having said that, my experience is that oftentimes people put themselves or get themselves in litigation because there has not been the kind of open and frank process and communications up front to allow you to avoid that in the first place. And what litigation most of the time ends up forcing you to do is to finally sit down and have that conversation that in retrospect most people would say, gee, we should have had a whole lot sooner. But the litigation is what forced us to sit down and talk and work this out. And again, I think in many ways this does come back to resources both for the states and EPA. And we need to look at what do we need to provide in terms of resources and possibly process improvements, some other ways of getting additional communications going on early in these issues so that we don't find ourselves having to litigate these things. We can talk it through, work it through, and come to some common sense solutions. We'll never be able to avoid all the litigation. I don't think that's possible. I'm not sure that would be a good outcome for us anyways, quite candidly, but I do think in many ways this comes down to just how do we improve communication.
I would just add to that in in some discussions, it seems like there are requirements that really do not allow EPA to have the discussions where we think those discussions need to occur. So there may be some impediments statutorily or regulatorily. I'm not sure where that is, but I know that there have been times when we've had that discussion and it could not be resolved because of the process. And so I would ask that, that would be something that I think has some value in looking at is, are there some impediments that are in the federal system that really prevents us as equal partners, as regulators, co-regulators, to be engaged in it? I think that would be very helpful.
Again, from the tribal perspective, Representative Bilbray kind of prompted me on this when he mentioned what role Interior has. Interior is the primary trustee in the federal government, but when the EPA takes an action or another executive branch agency takes an action, oftentimes we find the agencies aren't talking to each other.
Yes, if it was the DOD, if it was a military reservation, you would have the DOD at the table. That's goes with it.
Yeah, and I don't think our situation is unique just because we're a tribal government and the federal government is trustee for us. But there are many instances where you find that the federal agencies have varied interests and they just don't talk to each other. Again, another point on open and upfront communication lines I think is critical.
Well, let's be real blunt about it. The fact is that litigation is used also as excuses for doing things and moving agendas, basically by saying, well, we've got a litigation issue here, so we have to come to a consensus with the litigant. And this is where we come over and we announce to the locals that there's been this agreement with a litigant, and so here's what the new game is. And sadly, that has been done more than it should ever have happened in an open society, in my opinion. I think there's a lot of backroom deals that are done with the excuse that litigation forced them to have to settle on something that nobody was allowed to know about. And frankly, a lot of it, I think, is preconceived agendas that sadly should have been done out in the public forum.
Yeah, that lack of transparency is a real concern, I would think, and particularly if you are a state that's going to be dramatically impacted by a settlement agreement that can out. Well, now, do any of you participants have any questions for other participants as a result of the discussions today so far? Anybody have questions for anybody else? Yeah.
Well, as I mentioned in my opening remarks, we are situated where we're working with 4 states as our neighbors. And we also work with EPA under the banner of partnership, and we're striving to be co-regulators and co-environmental managers with the federal level as well. So one of the things that I have a keen interest in, and will always be from this point forward for anybody that's going to continue this work and succeed me, is how we're going to continue to develop working relationships with our state partners. Ms. Marks here invited me to your next meeting of ECOS, and it's the first time that I've ever had an extension of an invitation like that. I think that one of the things that fundamentally has always been an issue is how tribal governments will be perceived as becoming co-regulators. The EPA does have an Indian policy, a policy about how it's going to work with Indian tribes, and it states in there that the concept of comity is supposed to be in place between EPA, the states, and the tribes. But across the nation, there's all different kinds of issues, which either brings us in alliance or puts us on opposite sides of the table. So, I just wanted to mention that one of the things that we're interested in out in the Southwest and continue to try and do our part, coming from Indian country, is to find ways to work with our state partners and show that a tribe like the Navajo Nation that has fossil fuel-based economy is going to weather these tough times where coal is looked down upon, and do our job to ensure environment and public health issues are taken care of by our own people, my staff, and to show that we have an ability to work with our state partners towards the same goals.
Well, I want you to know one of the reasons we had this meeting was so you'd be invited to ECOS.
Success.
Yeah, right. Yeah. Is there anyone in the audience who would like to ask a question? You made it so clear that no questions. Anyone here would like to file a comment or? Thank you. Well, let me just say that I want to thank you all very much for coming. As I said in the beginning, this was meant to be a listening session without any preconceived thoughts of where it would go or anything else. But I do think it's important because of the magnitude of the Clean Air Act and its impact on environment, economy, and so forth, that we do have an opportunity to sit down and discuss the act because we haven't really discussed it since about 1990 in a meaningful way. I know you all talk about it at ECOS a lot, but in Congress we really haven't had an opportunity to have any discussions about it. So thank you very much for being here. If you have any additional thoughts on anything, please let us know, and we'd like to keep the line of communication open with you. I will say that we're going to have another one of these on Thursday, and basically it's going to be, there's going to be Mr. Colin O'Mara, who's Secretary with the Delaware Department of Natural Resources, Henry Darwin, the Director of Arizona Department of Environmental Quality, Susanna Hildenbrand from the Texas Commission on Environmental Quality, Steve Herrera, the Southern Ute Indian Tribe, John Paul with the Dayton Regional Air Pollution Control Agency, and Dr. Barry Wallerstein, Executive Officer, South Coast Air Quality Management District. And there may be more, but we're uncertain at this time. So with that, thank you very much, and that will conclude today's forum. Thank you.
Thank you, Chair.
You're very welcome.